This week we're focusing on outlines of argument. Now you might be thinking, I would rather spend most of my time working with clients and negotiating and working in a non-contentious area of the law. I don't want to be an advocate. It's still important that you learn how to draft an outline of argument for two reasons. One, you may still have to appear in an interim application, and for that you might need an outline. There are lots of pre-trial applications and hearings, and you might not always instruct counsel. Secondly, it helps you learn the art of persuasive writing. You need to be persuasive in a range of writing tasks, and of course you might need to be persuasive orally when you're negotiating. And learning how to draft an effective outline of argument will help you refine that particular art of persuasive writing. Now, the study guide takes you through the structure of an outline, and there's lots of detail and information in there. The reading is also comprehensive, so I'm not going to take you through that in this video. Instead, I'm just going to give you a few little tips for constructing an effective outline of argument. So let's look at tactics first. From a tactical perspective, you should always ensure that your first punch is the hardest. Generally, that means putting your strongest point first. Now, I'm not saying be illogical and take your points out of their logical progression. So, for example, take negligence. If you have two separate arguments, one on whether or not there's a breach and one on causation, you wouldn't deal with causation first, even if that's the strongest argument overall for you, because that is an illogical presentation of the arguments. The court only needs to turn its mind to causation if it is convinced that a breach has occurred. So you would still have a breach section before a causation section, but within those sections you should ensure that your strongest arguments come first. What that means is that you need to be very careful when you plan the document so that you have identified how many arguments feature under each section or heading, and then identify which of those will appear first. In addition, quite often you'll have to make arguments in the alternative. Now, what we mean by that is, if the court's not with me on that point, then I have this point. So going back to our negligence example, if the court is not with you on breach, you've still got things to say about causation. Now, you need to be very careful when you're presenting alternative arguments, and you need to highlight or flag this for the reader so that you don't implicitly suggest that you are admitting a particular point. So, for example, if your primary case is that no duty of care is owed at all, you need to make sure that your arguments about there being no breach are expressed in the alternative. Otherwise, when you're talking about breach, it looks like you're admitting a duty of care. So make that very clear. The court needs to know that you're only advancing arguments about breach in those circumstances if the court finds that a duty of care is owed. So the trouble with this area, and why it's quite tricky to find the right balance, is that you are in fact inferring that you're not 100% confident that you will win on the first point, i.e. duty of care. And so the phrasing needs to be carefully put, and both arguments under both sections need to be strongly asserted. It's quite difficult to achieve, and you probably won't get it right the first time that you do it. In practice, look at what others do. Try and identify why you're really convinced by their arguments. How do they express the content? And that will enable you to start mimicking their expression and tone. You can start to identify why they've presented things in a particular order, what's logical about what they've done, and how have they managed to take a weaker position and turn it into a strength. Crafting a persuasive argument takes learning through experience, exposure to the work of others, and the fact that you keep working at it and reviewing what you've done and identifying how to improve. Now, as I've already said, crafting a persuasive argument takes learning through experience, exposure to the work of others, and refining your draft over and over again. But there are some basic components of a persuasive paragraph that we can look at now. Now, this is just the beginning of the story rather than the whole story, but if you use this approach, it will help you formulate a persuasive argument. So the first thing to do is start the paragraph with a really strong assertion. If possible, this should be just one sentence. Think about, in summary, what are you trying to say? What is the point of what will follow? You're basically alerting the judge to your position at the outset so that if they don't bother reading what follows, they at least know what you're arguing. So once you have identified hopefully one sentence which summarizes your position, think about how to express that particular sentence. It's the most important sentence in that paragraph. How can it be strongly stated? What language can you use to achieve that? For example, you might initially start off with something like, it is submitted that the applicant has met the grounds X and Y, blah, blah, blah. Instead, you could reframe that and say, take out the it is submitted because that's just weak language. It adds nothing. It's frequently overused in outlines, so just delete that entirely and start off with something like, grounds X and Y are clearly met in the circumstances for the following reasons. Now, even that can be beefed up even more than that, but that is certainly a better version of that position statement. Once you have your position statement, or sometimes known as your topic sentence, in the paragraph, you then move on to providing your reasons. These need to be logical, they need to progress well, they need to flow, and here is where you cite your primary sources in support and use authorized law reports wherever possible. You then may find that that's a particularly large bulk of text, so consider whether or not you need to spread out those reasons over a number of subparagraphs. Subparagraphs help the judge understand that they are connected back to the principal argument and it's not the commencement of a new set of reasons or analysis. Now, if it's really complex, you might also need to use subheadings. That really helps the judge go to the bit of information that they need. And finally, that paragraph or the series of paragraphs that provide your reasons need to have a conclusion, a strong conclusion, before you move on to your next point. One final tip, you need to put yourself in the position of devil's advocate. You need to identify the strengths and weaknesses of your own case so that you can try and counteract some of those weaknesses with a persuasive argument. You also need to identify the strengths and weaknesses of your opponent's case, and that's where playing devil's advocate comes in. Imagine you were acting for them. What arguments would you make? What arguments would you say are particularly strong? And you need to then try and formulate a response to those. You would also, in your own outline, want to highlight the weaknesses of the other side's case. If you read the case and you start to formulate a plan for your outline and you think, yes, the other side are really weak on this point, don't be frightened to explain why it is weak in your outline and then assert why your position is strong. But make sure you do so respectfully. It's unprofessional to be disrespectful to the other side. We don't want to use language that is disrespectful. We can assert our case strongly but professionally as well. Now, the study guide also talks about a range of other ethical considerations, including the lawyer's overriding duty to the court. This extends to outlines as well, so you need to have that at the forefront of your mind when drafting. Now, in the workshop this week, you're required to provide feedback to a fictitious student on an outline that's presented in the workshop materials. When you're thinking about what feedback you would provide to that student, look at the thing overall as a comprehensive document and then go through it line by line. You should be providing constructive criticism in this process. So how would your tutor express criticism? Note that it's also important to give positive feedback as well. What aspects of the outline work well? The student needs to know this so that they keep doing it, and you need to take note of what works because you might want to mimic that in your own outline. Going through this process and looking at it from the perspective of the tutor means that you're more likely to be aware of the problems in your own work and what can be strengthened, and identify how to improve your draft before submission. So it's a really important exercise, so please attempt it before you come to class. Okay, I'll see you in the workshop.